first important overlaying legal phenomenon that anybody in the creator world should know about are FTC guidelines. Social media is incredibly powerful. It's powerful as a creator, it's powerful for business, it's powerful even for attorneys. These clauses allow brands to be compensated, indemnified, reimbursed essentially, by the creator in the off chance that the clients face legal action stemming from the creator's work done on the brand. So morals clauses are on the rise. And these are essentially ways for the brand to protect themselves in the event that the creator does something to get themselves canceled. And the brand wants power over either paying the creator or having the creator take down the content.
My name is Nina, and I'll be the moderator for this webinar. I wanted to start out by giving a bit of background on our speaker, Julian Serafian. Julian Serafian is a lawyer and content creator. His law firm, For Creators by Creators PC, is the premier law firm focused on representing content creators and social media influencers. As a content creator himself, Julian produces videos and blog posts related to the legal profession, law, and mental health on TikTok, YouTube, LinkedIn, and Instagram, where his cumulative following is nearly 350,000. He has written and published op-ed pieces in The American Lawyer, Law 360, Business Insider, Bloomberg Law, and CNBC. His advocacy for mental health has also been covered by the New York Times and Bloomberg Law. The webinar presentation you're about to watch will be approximately 1 hour, and Julian will be joining us for audience questions after the presentation is complete. If you have any questions that come up during the presentation that you'd like to ask Julian, please place them in the Q&A button at the control panel at the bottom of your screen. Now, without further ado, here is Julian to discuss content creator law by a content creator.
Hello, everybody, and welcome to Law in the Creator Economy. My name is Julian Serafian, and in today's lecture, we're going to deep dive on the legal terms that show up in the creator economy, a high-level overview of what the creator economy is, the money in social media, why this is really important, not just for you as a lawyer, but for you as a citizen and as a human being, because these platforms, these tools, they are only getting more and more prevalent in modern-day society, as I'm sure you're well aware if you have children and you see them using all of these various pieces of tech. So let's get started. First, let's talk about moi. Who is it giving this lecture? I'm an attorney. I graduated Harvard Law School in 2018. I'm in California, West Coast, Best Coast. I have no shame about that. And I used to work in big law at big law firm Wilson, Sonsini, Goodrich, and Rosati. They are a powerhouse Silicon Valley firm that works primarily with technology companies. They're a big law firm. And I worked for them for about 3 years before quitting during the pandemic to explore other endeavors and work on my own mental health, which had taken a huge beating during the pandemic, as I'm sure it did for many of you out there too, because the pandemic was really rough. Nowadays, I'm a law firm owner. I run my own shop, For Creators by Creators PC, and my firm primarily represents content creators, social media influencers, social media agencies, and folks that are adjacent to or in the creator economy world and industry. But in addition to that, I'm also a content creator myself. So you might see me pop up on your LinkedIn or your TikTok or maybe even your YouTube sometime talking about law, mental health, politics, social policy, or just giving career advice and paying it forward to the next generation of lawyers because I love doing that. But most importantly, I'm the guy that's on your screen for this class. It's great to meet you, albeit virtually. Okay, let's talk about the power behind social media, because I'll be honest, if you told me when I was in law school or even when I was in big law that I would end up carving a career out of the social media space, I would have laughed at you, because I would have said social media is for either like very, very attractive people in LA who, you know, have the looks and they have the personality and they have the lifestyle that curates and caters to building an audience, right? Or it's for posting memes and like making fun of the status quo by creating like silly content, but that's not even really a career. That's more of just generating some sort of, fun and engaging content. But I learned very quickly in my adventures after big law how powerful social media is. And if you do some research and we're going to talk about it, I think that you'll agree with me. So, first of all, it's one of the most utilized digital activities, period. And it's only growing. There's a lot of reasons why it might be growing. I think the main one is that people are getting older. As the older generation, transitions out and the younger generation transitions in, the younger generation is beyond just being natives to technology. These kids are plugged in from the womb, to the various social media platforms and just content generating platforms that exist out there. And it's second nature to them. So that's probably only going to increase as the rate of usage gets higher and higher with the younger generation aging upward. So as of 2021, 4.26 billion people are actively using social media, expected to grow to 6 billion by 2027. That's stunning. I mean, if you conceptualize that for just a minute, it's nearly half of the global population, and it may well be more than the global or more than half the global population by 2027. This 6 billion number, I have a feeling, is conservative too. The thing with the creator economy that we'll touch on later is that the growth in it has been exponential. Venture capitalists, when faced with entrepreneurs pitching creator related companies as little as 4 or 5 years ago, laughed at their face and said, there's no way this industry is even going to be worth $100 million by 2023. And now it's worth well over several $billion as an industry. Now, social media itself is important to think about because, as you may be aware if you use it, its draw is that it's masking as social time for you as the user. I mean, it's the way that you keep in touch with your old friends. It's the way that you connect with your new friends and develop new relationships. And it's the way for companies and brands to market themselves to new customers, to their existing customer base, and to build a personality that they otherwise just wouldn't have on the internet. That's what social media allows for us to do. That's primarily why I think it's very popular. I don't think many would disagree with that. And the last point I want to touch on here is there are, I think, some misunderstandings about what social media currently is, because if you're around my age, I'm around 30 years old. It used to be, when it came out, very much a platform where you would connect with your friends. Just like I was talking about, the thing that drew you in is, oh, I can talk to my high school friends or my middle school friends. I can keep in touch. We can post photos. We can share on each other's wall on Facebook, all that sort of stuff. Over time, and this isn't the best thing, but it's happened, mainly because I think these companies are profit seeking, and this is the most profitable way for them to curate a platform. These platforms have shifted slightly away from being purely about connecting peer-to-peer and human-to-human, social-to-social interactions, and they've shifted to sharing raw information instead. And information can come in a variety of ways. It can be a meme, like we just talked about earlier, just original content that's sharing like a vibe or an inside joke or relatable content, or it could just be legitimate information. Here is when the United States was founded, and here's a brief overview in a short video that's 30 seconds with really good editing. In my case, here's some information about these various law schools, for your pre-law students, so you can think about and weigh what law school is the best fit for you. Here's some information about a law firm. Here's some information about this new act that Congress just passed and President Biden signed into law. People are drawn to these platforms to gain value. And the days of going on them just so they can see what their friends are up to, they're long gone. You have a little bit of that on the edges. And I think Facebook has shifted back towards it after being criticized heavily for shifting too far to the side of pushing information and memes and things of that nature onto people. But this era is here to stay. And this is relevant for our discussion because in the future, content creators, I think what you're going to find are going to be really focused on this aspect of social media, the information sharing, not necessarily building a relationship or selling a brand or selling their personality, as much as I have a cool perspective because I do this job. Let me show you what it's like to be in this job. Let me tell you about it. Let me share my expertise with the world. And people love that stuff. So some more data points for you. The average person uses 7 social media networking platforms per month. It's a lot, but not as scary as the next statistic. The average person uses social networking platforms for 95 minutes per day. An hour and a half, that's a full-length feature film every single day that the average consumer is deciding is worth more on social media, on Instagram, TikTok, YouTube, LinkedIn, than watching a film. Whether that's good for humanity or bad, I have my own thoughts, but what can't be understated is that these this usage and the power of these platforms is second to none here. Facebook is still dominant. It's the most used platform by marketers worldwide, and that's primarily because they have the most data on their consumers and they've cracked the code for effective targeted advertising. So advertisers actually know if I do a good job targeting my consumer, I can actually convert sales. It's a problem that I think platforms like Twitter have not yet solved. Facebook is responsible for a quarter of all advertisements you see on the internet. That's probably going to increase over time too. Average use of 33 minutes per day on the platform. Instagram, which as we know is owned by Facebook, now Meta. Highest engagement for streaming service advertising at 81%. It's a 6 times higher engagement rate than Facebook, just for your benefit. An engagement rate is the rate at which people are actually liking or commenting or sharing a piece of content, not just viewing it. Viewing it is engagement, but when data crunching folks look at engagement rates, what they're really focused on is, are people liking it? Are they sharing it? Are they commenting on it? By the way, when you do that, you're telling the platform that that's a good piece of content that it should continue to share. So a lot of content creators, when they're first starting out, they'll get their first hate comments, and it's a very exciting moment because, first of all, wow, someone's hating on me. That means that there's something here. There's value. But also, wow, they're hating on me and they're commenting on it, which is going to generate more feedback in the system that tells, TikTok or Instagram, hey, this content is exciting. We should push it to more people. So they're actually helping the creator by hating on them. And that's what a lot of creators say. Thank you for paying our bills, trolls. Back to Instagram, though, 44% of IG users use Instagram shopping weekly. And Instagram shopping is, if you're not aware, it's one of these features where you can buy things directly from Instagram or from creators who list their products on Instagram. But Instagram, as powerful as it is, it's not as new and sexy as TikTok. TikTok came out of nowhere in 2019, 2020. And since then, it's been the fastest growing platform, 105% growth rate in the past 2 years across the US. It's not going to get banned. Don't even start that discussion. It will never happen. Never. For a variety of reasons. Mainly because it has way too much clout amongst Gen Z and a lot of other people in the United States. To ban it would just be, amounting to censoring all of those people, including myself, who have built a platform on the app. So I think if anything, the United States will work on an acquisition of it. But in any event, as I just mentioned, very popular with Gen Z. It's the most popular social media app for them. Nearly 40% of people in a survey said they're most likely to purchase products they discover from TikTok endorsements. That's huge. And TikTok is actively innovating and creating new features to grow more rapidly and to make money, most importantly. Most recently, TikTok Shop was introduced, and this is similar to Instagram Shop in that you as a creator can pair up with a product that you like and say, hey, I use this product when I study, law school cases, and here it is in my TikTok Shop. And then however many people buy it, you will get a commission cut from those sales, and that transaction can take place in the app. Pinterest has 400 million monthly active users, and shoppers on Pinterest utilize the shopping feature more than on any other social networking site. So if you want to pause here and take a look at some of this data, I think that you can see that there's a lot of money flowing into this industry. We're going to talk about this later, but the main way that creators make a living is through brand deals. When a brand comes to a creator and says, hey, your audience likes something that's in I think that your audience will like my product or service. I'm going to pay you, let's say $1,000. You're going to then do a video talking about it. So that's where a lot of the money goes, both for the creators and to the actual platforms themselves. And the platforms want they want their algorithms and their service to create an effective advertising machine, because they know that if they don't, then they don't draw in those advertiser dollars. And you can see here that Instagram and Facebook are both very high, by way of where companies are going to spend their advertising money. TikTok is lower, and that shouldn't surprise us because TikTok is a newer company. I don't think that they have as much data as Facebook and Instagram, so the targeting is not going to be as good, and they're still figuring it out, right? But TikTok certainly has millions of people, 100 million plus in the United States using the app. So I think we can expect these numbers to go up for sure. And of course, the right side column is the more relevant because it was a couple of years ago rather than 2019 when TikTok had just come out. Notably, Twitter is down here at 32%. They've historically struggled a lot. We'll see if that changes now that it's called X and Elon Musk owns it. But given all the Nazism on the platform, TBD. Okay, so let's talk about social media influencers themselves. You might be wondering, like, what constitutes a social media influencer? Are there tiers of them? And that's what we're going to get into with this slide. So, as I talked about earlier, I think we all need to make a shift in our head of what a social media influencer is. It's no longer the Kylie Jenners of the world, where every post is them with a Ferrari or a beautiful mansion in LA and Beverly Hills. That niche is always going to exist. It's always going to be around. There's going to be new ones. I'm not saying that it's dead. Of course it's not. But there's a new era and a new genre of creators out there who are a bit different. And those are the ones kind of like myself who are just either career professionals or just people just creating interesting content or talking about things or sharing information. And if you get into the numbers, you have what is generally known as a nano influencer. That's 10,000 followers or less. Micro influencers, 10 to 100K. Macro, 100K to 1 million. And sometimes I'd say micro, some people would consider less than 500,000 micro. So these are not like hard and fast rules. It's more like general guidelines. So some people say up to 500K for micro, and then anything above that is macro. And then there's mega influencers, which are over 1 million. We've touched on this. I won't spend too much time here, but the basic thing you need to remember is you could be, I think the best example of like the old versus the new is somebody on Instagram posting photos of their lifestyle, their brunch, sells an image, sells a brand. It's very different than a LinkedIn influencer who purely communicates primarily through written content, thought pieces, maybe never posts a photo, never posts a video, but still has hundreds of thousands of followers, is famous, monetizes with their audience, does brand deals, right? They walk and talk the same way when it comes to being a creator on the monetization side, even if they're producing very different content. And one other point, in the old days, it wasn't as cool to be authentic or raw on camera. But with the advent and dominance of short form video, being authentic and raw, whatever that means to you, a lot of the time, I think it means just being super passionate, just letting it all out, crying on camera if that's what you feel in that moment, just not censoring anything, not curating it. That can really pop off on these platforms. And I think it's just an interesting angle for all of us to think about because everybody can be authentic and raw. Not everybody can drive around in a Lamborghini and take photos in LA, right? But everybody can be authentic and raw. Everybody can be a human being. And that's what people are drawn to. Now, building a brand from that's a different story, right? It's not that simple as a content creator to have one viral video and expect to be an influencer now. That's not how it works. You have to continue to curate content and make interesting content that resonates with an audience. But certainly being authentic helps with that. And that's, I think, something new because like we've talked about, on these platforms, especially Instagram. I think the opposite was true for a long time. It wasn't really authentic. It's like super curated stuff. People will like pose for photos that seem, or it'll be a staged photo, even though it's purporting not to be staged. It looks like it's authentic, but it's really not. But it's a lot harder to do that on video. And I think that's what we've been seeing. But in addition to that, you don't have to even necessarily create your own original content all the time. TikTok, a part of the reason that it's grown so rapidly is because it's given creators an assist in producing content in the form of trends and dances and original TikTok sounds. When you do a trend, you just follow the trend. It's like a formula, right? It tells you what to do. You just plug in yourself on camera doing the right actions and putting the text where it belongs, and you have a video. And on top of the fact you have a video, it's generally going to be pretty popular because people on the app are drawn to the trends because everybody else is doing them. So the creator already, or the consumer rather, already understands intuitively what they're going to be getting. We've talked about information sharing just as a side tangent here. So many doctor influencers. If you are a doctor, my God, I mean, people love learning about medicine. You go on these platforms, you just start rattling off facts about medicine, and you will get thousands of views. I guarantee it. Not as easy for law. Law, I think it's more perspective based and judgment based. It's more like gray area. That's kind of the nature of the profession. Our profession, we're not as locked down or as quantitative as medicine, but there are so many doctor influencers, and that's only going to increase over time too. But I think it's a great example of what I was talking about earlier with pure information sharing. These people are not selling a lifestyle or a brand at all. They're just telling you, here's why vitamin C is important to you. 5 benefits, listed in text in front of just their face as they're sitting at a desk. And these people do really well. I've several of them as my clients, and they're doing a really good job. The last point, these days, video is the dominant sort of content. If you want to succeed, if you want to grow on these platforms, doing it through posts, still frame images, text-based written articles is going to be much more difficult. TikTok is the main engine of growth these days. It's the way that you can go viral the most easily. And TikTok is essentially a short form video app. They have a little bit of optionality nowadays for posting photos where people can swipe through, but those posts typically don't do as well as videos. So if being a creator is something that you're considering, or those around you are considering, you got to get on camera and do short form video. Now, why are we even here? Why is a lawyer telling you about social media, and what are the implications of this industry financially in the long term? We touched on this before, but let's dive into it now. Most of the money that's flowing into social media, both to creators and to the platforms, is advertising. This is a way to get in front of eyeballs. When you're paying a creator to advertise your product, you're choosing a creator that probably has an audience that you think will like your product, and you're betting on the fact that when 20,000 of those people see the product being shoved in their face by the creator, the social proof of that creator with their audience and the fact that they now know your product exists will be enough that consumer will turn around and then purchase the product. That's the bet. This is basically micro television. In the old days, there was no social media, there were no phones. People would pay, advertisers would pay to be listed on, the news channel in between segments as a commercial. Hey, everybody, go get this product. Nowadays, I feel like it's mostly just like medicine for old people. But on social media, it's not. On social media, it's everything. You're right. People are advertising everything. Yesterday, when I was scrolling, I got an advertisement for an ADHD related tool to help you be more productive. I got an ad for a pillow cube. I got an ad for some dog products. They're getting better and better at reaching their target audience. And creators specifically, it's definitely a wild west here in terms of where the value is. Like, there's a lot of brands out there that are paying creators and then getting nothing out of it. And there's a lot of, at the same time, there's a lot of brands that are giving creators nothing and getting a lot out of it. I think I may have said the same thing twice there, but I think you get my point. uh people don't know. There's really not many data metrics or data points or even like centralized information here that informs brands or even creators on like what the standard is. It's very much still developing. However, what remains true is the general principle that if a brand sees you as a sports content creator and they're selling some sort of sports product or sports blog, then they think, okay, your audience is my audience. Your audience is my customer. If I pay you, then I should most likely have some success here in getting people to come over to look at what I'm making. And of course, creators make money from these brand deals. Many of them rely on this money for their income stream because these platforms are not paying creators much money on their own. YouTube pays the most through AdSense, but that's based on the number of views you get per month and whatnot. And even that money is limited relative to what you get from brand deals. If you want to look at like the biggest example, Mr. Beast. I mean, he's probably getting a lot of money from his AdSense because he's getting hundreds of millions of views on his videos. But I would wager that he gets more money from the brand deals that his company and organization is doing. When he tells you, hey, you should go to Honey and get this, plugin to save money on the internet. I mean, they're paying probably millions of dollars at this point, maybe even tens of millions in some cases. Um, and behind every one of these relationships, there is a legally binding contract. There are terms that are negotiated, and we're going to touch on that. So, it's a multi-billion-dollar business, as we've been talking about. Creators, however, they're not being treated fairly here. This is the main reason I got into the industry. I saw in the first brand deal that I got a lot of terms that were red flags, and I pushed back on the brand. I mean, I had a legal background. I just did transactional work for 3 years. I'm like, I know how to do this. I'm like, what, can I push back on this term? And the brand's like, no, we don't do that. I'm like, okay, that's sketchy, but I mean, I want the money, and I guess I don't have a choice, so I'll do it. But that sort of mentality is very prevalent in the industry. And I always tell people, not even self-interestedly, if you don't use me as the attorney for yourself as a content creator, go to somebody else, but like get an attorney to review these things, because creators are giving away rights left and right here, and they're signing on to terms that are just egregious, and at a baseline they're just unfair. But they don't know it because many of these folks are not attorneys. A lot of them are actually kids. I went to Vid Summit, which is the annual content creator conference for video-based content creators and industry insiders. And I think the median age there was probably like 24. This is very much a next generation economy that people are focused on. Older folks just either don't have the time or interest, or they're scared of the internet, which I don't blame them for. But in any event, these folks are young. Many of them don't have professional backgrounds. And even if you do, doesn't mean that you have the legal background or knowledge to understand what you're signing on to. So to that end, most creators do not have legal counsel. They just Wild West it. They go in, they're like, well, the contract is simple enough. They think that it's simple enough because typically they're not like 30 pages. They're usually like 3 pages, maybe up to 5. And I would wager like half of the terms they could probably understand, payment, the name, notice provisions. Oh, if we get sued or we need to contact you, here's the notice provision. But there's others that they have no idea that their eyes gloss over, but it doesn't matter. A lot of them just are excited at the prospect of getting paid, and they don't think through the complications. So part of what I've been doing as a lawyer for creators, aside from actually helping creators on the legal side, is educating as much as I can on my platform that creators should take these things seriously. And there haven't been yet many high profile cases where creators are getting massively screwed on the legal side. But I fully expect within the next 5 to 10 years that that's going to happen, because even though this industry is very young, it's going to mature. And when it matures, that's when you're going to get the fangs come out of brands, and they're going to go after creators for various things, or they're going to start exploiting creators. For example, if the creator signed over their name, image, and likeness, these brands are going to start just plastering their face everywhere without any regard to the creator, right? It's going to happen. It's just going to take time. It always does. Now, you might be wondering, how are these deals priced? We talked about Mr. Beast making millions per video. I mean, he's such an outlier. I wouldn't even begin to try to understand how they price his videos, because he's literally the king of content creation. But In general, there's some factors that go in to the decision for negotiating the price for a piece of sponsored content. Of course, what platforms are you on? That's very important. YouTube tends to be, for example, a lot stickier. The audience there tends to have a deeper connection with their creator, and so conversion tends to be better relative to TikTok, for example. Influencer reach, the number of followers you have, that's the biggest one. It's the easiest proxy for brands to think about how many people am I going to reach by matching with this creator. But the engagement rate is arguably more important because that shows, are people actually paying attention to the content this creator is posting. You can have 1 million followers, but if your engagement rate is like 0.2%, that means you're getting what, like 2,000 views on each video. I mean, it's nothing. You may as well have like 2,000 followers at that point, right? So engagement rate arguably is more important, but some brands just don't look at it because, again, this is a wild west and everybody's still trying to figure it out. The niche you're in is super important. Lifestyle, finance, those areas tend to do very well. Beauty tends to do very well. Not as much yet for areas like law, business, the type of products or services that folks like, for example, me as a lawyer can sell to my audience. There's more limited. Whereas if you're a beauty creator, you have like, thousands of beauty related products out there where the brands are eager to sell. The type of content that they want, if they want a photo, if they want a video, that could determine the price. Usage rights, which determine basically if you're allowing the brand to step in and boost the content as a paid advertisement for an X number of months or even years. Exclusivity, is the creator signing on to a non-compete and thereby limiting themselves. But when it gets down to the numbers, the benchmark that I use and that I've seen that's most accurate is for a sponsored video post, the payment rate is about 1% of the TikTok following and 3 to 5% of Instagram following. So myself as an example, 300,000 on TikTok, it's about $3,000 per video, 10,000 on Instagram. I mean, it's closer to like 15,000 now, but whatever. $300 to $500 per post. And that's, again, 3 to 5% of Instagram, $300 to $500. 1% of TikTok, 300,000 is 3,000 per video. That's a rough estimate. And that's a benchmark that I recommend for clients who are trying to price themselves, but it can be significantly higher if you're in a really if you have a really sticky audience and a really powerful brand. It could be higher, 100%. It could also be lower if your content's kind of not on target for what the brand wants. Now, because I've said this a lot, and I'm going to hammer it in again, this is a Wild West. And in a Wild West, you have a lot of inconsistent and sketchy behavior happening. Brands will claim they have no budget, even though they do. And that's just a way to not pay the creator who's asking for money. They'll lowball creators all the time. One of the most common tactics brands use is they offer an affiliate or a promo code, which is rather than a flat fee. So basically they'll say, we're not going to pay you at all for the content, but for every person that buys through your link, you'll get $1. And a lot of creators will see that and say, that's great. I can make money now. And that's true. To be clear, it's not a bad thing. Like affiliate marketing is huge. And if you do it right, you can make a lot of money. But what the brand is not telling you is that they would also be willing to pay you for the post in addition to the affiliate marketing code and relationship. You just have to ask for it. But a lot of them will offer that up front. And in general, the newer and more inexperienced the creator is, the more often these brands are going to prey on them. Okay, that was a lot of information. We're about halfway through. Let's take a breather, short 3-minute break, and we'll come back. So go get a drink of water, go to the bathroom, stretch your legs, take some deep breaths, and we'll dive into the more fun and exciting legalese of these brand deal terms. Hello, welcome back. I hope you had a great break. Let's continue on and finish strong, baby. So we're talking about the actual deal terms in brand deal agreements. If you're a transactional lawyer, this is about to be the best part of your week. If you're a litigator, you're going to be bored. But here we go. Okay. First important overlaying legal phenomenon that anybody in the creator world should know about are FTC guidelines, aka hashtag ad, hashtag advertisement. There's very strict rules here. The creator who's posting the video, they're the ones with the responsibility to disclose that this is an ad. It doesn't fall on the brand, it doesn't fall on the platform, it falls on the creator. So the creator needs to make sure, basically, that it's very obvious to the person on the other side that it's an advertisement. It needs to say hashtag ad in big text over the video, maybe above their head, or it needs to be the first thing in the caption, hashtag ad, or it needs to say paid partnership with. There's no clear right or wrong here, or rather, I should say that there's no bright line rule as to, okay, if you do this, the box is checked. Instead, the FTC standard is that they need to clearly and conspicuously disclose that there is a relationship. And I think those standards kind of need to be a little bit gray because the platforms are constantly changing. The type of content people are sharing is constantly changing. I think the FTC is going to really struggle if they say, oh, this is enough. If you hashtag ad, that's enough. Well, I don't think hashtagging ad may be enough if you're dealing with a platform where the caption is completely hidden and you only see the video, because now for the average consumer seeing it, they're not going to see it, right? Like there's so many nuances like that keep appearing that instead it just falls on the creator to make sure that they're protecting themselves. Bottom line is the creator needs to make sure that it's obvious. And hashtag ad is a great way to do that. Paid partnership language is a great way to do that. Many of these platforms also have a toggle of is this paid partnership or is it not? And if it is, then you can toggle that on, and that will 99.9% of the time satisfy the FTC guidelines, because when those videos show up on people's screens on the other end, many a time it'll say paid partnership. It's like a disclosure that the platform is built in to help you. If you want to see some of these guidelines, by the way, they're in the extra course materials to this class. Okay, the first term we're going to talk about, this isn't really a legal term as much as a business term, but of course it shows up in these brand deal contracts. What are the required deliverables? AKA, what is the brand paying for? Are they paying for a video? Are they paying for an Instagram post? Are they paying for a LinkedIn post? Typically, what these clauses include is they include a video or a post, some form of content or a number of content pieces, aka like 2 TikToks, 3 Instagram reels. And also the creators promise to link the brand services or products in their bio, which is the link when you go to a creator's profile, they have a bio link, which is like a website. And typically what creators do is include a bunch of links in that one link. This is getting confusing, but like the important thing that you need to know is that the creator is saying, I will include your link to your product in my family of other links that I'm sharing with my audience. And that's typically for a period of time. Yeah, it's better to be specific. That's what this last bullet point is getting at. If a brand just says, do a video, it's like, okay, well, I can do a video, but like, what do you want the video to focus on? Is there a new feature that's being rolled out? Are you looking for views or are you looking for conversion? Sometimes brands want different things. I think it's always prudent for creators to clarify these things with them before they actually make the video and post it, because then they'll be able to do a better job. And now let's turn to the legal terms. Non-compete clauses. These are more or less straightforward. It's just like it sounds like. If a creator signs a non-compete clause with a brand, then it's saying that they're typically promising not to work with competing companies in the social media space for a period of time. There was one time, the first bullet point you'll see here, which was out of this universe. I saw it in a client agreement. It said you can never work in content creation again after this post. Bro, what? That's like absurd. That's saying that you quit the entire industry just for one brand deal. Absolutely crazy. I completely struck it, and the brand didn't fight me on it. I guess not surprisingly, but But non-competes can get pretty egregious in that way because they're powerful. They lock the creator in and limit their ability to work with other people. Most often, non-competes show up when it's bigger brands that are doing deals. We're talking like Sephora, Walmart, HelloFresh, like that level. And typically they're pretty limited in duration. I think I would say on average it's anywhere from 48 hours to a week of blackout non-compete time, and it's based on when the post actually goes live. So the language will say something like the creator agrees not to work with any competing or post any sponsored products with the following competitors for the period of 48 hours before and after the sponsored post goes up. And then it lists all the competitors. So this example is definitely not common. You can never work in creation ever again. That was a story for the lore and for legend. Okay. Location of suit, jurisdiction of choice. I think many of you will probably know what this is intuitively, but yeah, if things do turn legal between the brand and the creator, where is the litigation going to have to happen? What type of law is going to govern the issue? That's governed by the location of suit, jurisdiction of choice clause. Typically, the company is going to write this clause in their favor, so it's going to say off the bat that the jurisdiction of choice is whatever city or state the company resides in. But that doesn't mean that it's not open to negotiating. Creators can certainly negotiate and push back on this and change the location. And I'd say in my practice, I have success in that about half the time when I actually want to change it for my creator clients. So I think brands are open to it, but you got to actually ask for it. This is one of those clauses that I think creators think they understand. They see it. They're like, yeah, I can read those words. Those mean something, but then that's it. There's no further analysis. And then they don't negotiate or push back on it, even though if they knew what it was doing, they'd probably push back on it. So back to our discussion earlier of like the importance of legal counsel, I think this is like one of those terms. But if they think they know that term, I can guarantee you creators have no idea what's going on with indemnification terms. This was one of the major sticking points that I had with my first brand deal agreement that I read, and I'm like, dude, this is obscene. How am I signing on to this? So let's talk about it. These clauses allow brands to be compensated, indemnified, reimbursed essentially by the creator in the off chance that the clients face legal action stemming from the creator's work done on the brand. So for example, I do a brand deal with Coca-Cola. I get paid $1,000. I post a video, me drinking Coca-Cola. Someone scrolling TikTok sees that ad. They are inspired to buy Coca-Cola. Wow, look at him. He's so happy drinking his Coca-Cola. I want a Coca-Cola. They go buy a Coca-Cola. As they're drinking the Coca-Cola, it explodes, sends shards of aluminum into their foot, breaks their laptop. They decide to sue Coca-Cola. Like, this is your fault. You're negligent. And in their lawsuit, they talk about how they bought it because of the advertisement where they saw me. Coca-Cola spends $500,000 defending itself, let's say successfully. An indemnification provision would typically allow for Coca-Cola to come after me, the creator, for $500,000. Every single penny that they spent defending themselves. Even though the only money that I could have made from that relationship is $1,000 at most. No way I was going to make more. Maybe I could make less. I don't know. There's no way I was going to make more than $1,000. But the downside is now I could be out $500,000. And by the way, it could go higher. If that person sues Coca-Cola and it goes to trial and then they get awarded damages of $1 million and legal fees are $1 million, so $2 million total, they can come after me, Coca-Cola can, again, for the $2 million in damages and legal fees, simply because the creator, or the consumer rather, sorry, the consumer saw the ad that I had created, and because the contract that I signed with Coca-Cola had an indemnification clause in it. So these are very dangerous for creators. This clause is the thing that I think in the next 5 to 10 years, you're going to see a lot more action and recovery on, because right now brands, they don't want to be the bad guy and like bankrupt the creator for something, even though they probably technically could. but that's going to change. As the industry further develops, you're going to get bad actors, like really bad actors, in our industry on the brand side who are not going to care about the repercussions, on the PR side, and they're going to invoke these clauses to come after creators. It's only a matter of time. So they're dangerous clauses. Indemnification, they have huge impact on the creators, just the risk profile for what the creator is doing long term. And absent a cap on it, like we just talked about, the creator can be held responsible for the full amount of the lawsuit and lawyer's fees and damages, literally awarded damages, even if the influencer isn't really responsible. In the example we just talked about, why should I, as the creator who just advertised, is that my fault that the Coca-Cola can exploded? Like, no. Is there proximate causation because they saw my ad and then they bought it? Perhaps, but I think the fact that creators could even be on the hook for this at all is pretty crazy to think about. And yet, that's what a lot of these creators are signing on to. So generally, on the legal side, negotiating these provisions, what I try to do for clients is put a financial cap on how much money actually applies to the indemnification clause. For example, the influencer will indemnify you up to $5,000. We're not going to pay more than $5,000 in the event that this provision is invoked. This term, by the way, and you can see the language, example language of these terms in the extra materials, but this is very dense legal language. For transactional attorneys who are sophisticated, experienced, it's one thing, but for the average creator or consumer, they're never going to be able to parse through this. They can read it 50 times, they're still not going to get it. Maybe that'll change now that we have like ChatGPT and it can help like explain things if people are actually resourceful enough to use it, but TBD. Okay. Usage and licensing rights. This I touched on earlier, but essentially licensing and usage rights. This is more licensing rather than usage, so I'm going to focus on that part of it. But we're talking about name, image, and likeness here. And this is it's very close to just as impactful as indemnification. Many a times the brands in these deals will want to use the creator's profile, their name, their face, to throw into their own marketing materials, their own website, just to show off. Like, look, everybody, we have this creator who's awesome and they like our product and they've endorsed it. I mean, that's, I think, a reasonable ask. What's not reasonable is when the term says that basically forever and ever, the brand can use the name, image, and likeness of the creator in any way they want, in perpetuity, however they want it, period. There's like no limitation to it. Why would they ask for that? Well, as we've talked about, this is a Wild West. Why wouldn't they ask for it? Brands, if it can benefit them, they're going to do it, right? But it's impactful and important for the creator because, I mean, that could theoretically give them a right to plaster the creator's face on Times Square, or who knows, billboards nationwide in a way that the creator doesn't like. I mean, maybe the creator changes their mind about the product and doesn't like it anymore. Maybe the product has a bad rep down the line, but if the creator doesn't have any way to stop it, that's a big problem. And more importantly, if they're not getting paid for it, that's not cool. That's not fair. Many creators don't really understand the value of these terms. They think that it's like just kind of should be included as a matter of course. But in reality, if brands are asking for a significant length of time, I would say like a year or longer for name, image, and likeness rights, brands will pay a premium for it if the creator asks for it. But creators need to know that they should have the right to ask for it. In any event, it's important that these clauses are closely reviewed and that the creator understands what they're signing on to, because this is very much a business decision for them. Do I want to let them use my name, image, lines for 6 months, for 12 months? Do I even want to let them use it at all? Maybe I don't. Many creators, they're very, very specific with how they want their brand to be portrayed and used. And sometimes that means they don't even want the brand to have that right. They'll do the piece of content for them, but that's it. They don't want anything else to, be out there. But, as you can imagine, many creators don't really understand what this is saying, so they sign away their rights at no additional cost. So whitelisting, this is more on the usage side rather than licensing, but whitelisting is when a creator will create a piece of content, they'll post it on their channel, and what a whitelisting term does is it authorizes the brand to push that piece of content through the influencer's account to different people. So instead of the content coming from Coca-Cola, let's use that example that I just went through with indemnification. Instead of Coca-Cola's profile pushing the ad, what it's going to actually say is Julian Serafian. It's going to be my post, and it's going to be coming up as a sponsor post. It's going to be like a paid ad. The reality is it's not me paying for it, it's Coca-Cola paying for it. And companies do this for a variety of reasons, but a main one is that it looks and feels more approachable to a consumer. That's the theory, at least. If it's Coca-Cola giving you something, like obviously it's an ad. It's Coca-Cola's profile. What the hell else are they going to be sending you? What, saving your life, sending you life-saving medical advice or legal advice? No, they're showing you Coca-Cola. Be happy. But when it comes from Julian Serafian, suddenly, oh, it's a human being. It's a creator. Maybe this is something worth watching. Maybe, there's value here. So I'll watch it because I feel more connected. So whitelisting is something that's typically negotiated between the brand and the creator. Creators can go either way on this, I've noticed. Frankly, I don't mind whitelisting because what the brand's offering to do is boost my video and get my face out to more people. Like, I'm fine with that. I have no problem with it. There's still value in it, so I'll negotiate a price for it. But many creators are very, very protective of their brand, like I said earlier. And the thought of their face being pushed out as a paid ad to people that aren't in their audience, because the people that are being targeted by this are most likely just folks that check the boxes of certain demographics that the advertiser is saying on their end that they want. That doesn't sit well with a lot of people. So if whitelisting is included, typically it's financially compensated for. Anywhere from, I would say, 20 to 40% of the overall brand deal. That's how much money whitelisting on its own is worth. And, as a common theme in this lecture, as I'm sure you've picked up on, this is another term that influencers don't really understand that they should be limiting or charging extra for, so they just give it away. Morals clauses are on the rise. And these are essentially ways for the brand to protect themselves in the event that the creator does something to get themselves canceled. And the brand wants power over either paying the creator or having the creator take down the content. And the language can be very broad, but in general, what it gets at is something that the creator does that is immoral or morally reprehensible. I have issue with some of these, just as an aside, because they say politics, like they literally say anything that's bad, blah blah blah, including, and then politics. One time it said reproductive rights, aka abortion. It's like I understand that politics can be messy and aggressive and controversial, but to equate politics and reproductive rights with doing something immoral or morally reprehensible, that's just not it. That's not appropriate. That's not correct. And it kind of amounts in some respects to censorship. However, this is business. This isn't politics. So the brand has every right to ask for that. And if the creator signs on to it, they sign on to it. I will say also that most often creators are not political. They stay away from politics because of how divisive it is, and controversial, and perhaps not great for their content creation business. But anyway, morals clauses, they're on the rise. I think they're going to get bigger and more popular over time because it's a simple way for the brand to feel like they're protecting themselves. And in general, of course, the narrower this clause, the better. Okay, we're almost out of time here, so let me run through these real quick. Limitation of liability is pretty straightforward. It caps the financial amount of damages that can be recovered by either side if a legal dispute arises under the contract. So I think it's wonderful for creators because, now it can cap, for example, their liability under the indemnification clause we talked about earlier. I think that's great. I say these show up in about half of cases, half of brand deals that I review. So it's not the most standard, but I love it when I see it, and I add it in to my creators agreements when I think it's appropriate. Okay, so last topic I want to touch on. Everything we've just talked about has been in the context of brand deal contracts and the legal terms governing them, but there's a whole other sector of law that of legal work that's been on the rise in the creator economy, and that's defamation suits. This typically happens when there's influencer drama. So, here's a typical fact pattern. Influencer A says X. Influencer B says that's not true. Influencer A says it is. Influencer B then sends a cease and desist threatening defamation litigation if they don't take their post down. And then I get a phone call from influencer A saying, I got a cease and desist. I don't know what to do. I'm panicking. What do I do? What do I do? And I had no idea this was even happening when I entered the industry as an attorney for creators, but I just got more and more of these cases over time because it keeps happening. Sometimes it's not between influencers. It could be between a brand and an influencer. One of the benefits I think of social media is everybody has a microphone now. So you can go on there and be like, this dog hotel abused my dog. This is what happened with a client. They abused my dog. Here's the video evidence. Here's them saying that they were going to get me camera footage and they didn't. This is horrible. And then millions of views. And people millennials love dogs. Gen Z even more. So people just went ham on the Yelp page, the Google Maps page. They just one-starred it over and over and over. They tanked the social media profile of that brand. And then the brand sent the cease and desist to my client. And, most of the time these cases don't go to trial. They're settled either because one side will give up and stop threatening the cease and desist or defamation litigation, or the creator who is being asked to take down their post will honor the request, take down the post, and then move on. There's ethical implications to this issue. When somebody threatens a lawsuit and then that's enough for the creator to fold and take down their video, that's censorship. That's weaponizing the legal system. That's not something that we should allow. But it happens. It happens even to clients that I have, even though they have me, because I realistically tell them, look, if you want to defend yourself against this, it's going to cost a lot of money and it's going to cause a lot of stress. Is that worth it to you to keep the video up? Alternatively, you can take the video down and then the problem goes away. And I'm just being practically minded about it at that point. But at the same time, that's unfortunate that the legal system is still in such an arcane place that we allow that sort of thing to happen, and we allow folks to be silenced like that. So in any event, I think this area of creator law will continue to be an ongoing issue. And I certainly think it'll continue heating up because more and more people are getting on these platforms and becoming creators. More and more people are being inspired to use their voice as they should. And with that comes people who don't like the things that they're saying. Such is life. Such is life. Okay. That is it for me in this webinar lecture CLE on law in the creator economy. I sincerely hope that you enjoyed this and you walk away with a new perspective the next time you see an advertisement on your social media feed. If nothing else, I do want you to know that social media is incredibly powerful. It's powerful as a creator. It's powerful for business. It's powerful even for attorneys. It's not going anywhere. It's only going to get more and more prevalent and powerful, even if at the same time, on the mental health side, it is terrible for our mental health. It makes us more lonely. It distorts our sense of reality. And it gives us a false belief that other people are always having fun. And on top of the fact that it's just constant dopamine hits short term rather than deep thinking. So it's a double-edged sword. But that doesn't mean we cannot learn about it and take it seriously, because it's here to stay, and the money and the power in it cannot be understated. If you ever need anything from me, feel free to reach out. I believe my contact information is going to be listed here, but if it's not here, you can find me online. I'm on LinkedIn. I'm on, obviously social media, TikTok, YouTube, Instagram, and I hope to see you around someday. Be well out there. Take care.
Awesome. We have Julian here with us today to take audience questions. This is just a reminder, if you have a question for Julian, please feel free to submit it through that Q&A button at the control panel at the bottom of your screen. We already have quite a few. Hi, Julian. Thanks for joining us.
Hello, hello.
All
We're
right.
good, everybody. Thank you for joining us.
We can go ahead and dive right in. We've got, I think, 4 questions already, more rolling in. The first question we got was, what kind of checklist or something similar to that would be helpful in reviewing contract terms on behalf of content creators?
Yeah, I think so. It's a great question. The list of the terms that we walked through in this lecture are a great place to start. The thing that most creators care about are when they're going to get paid and whether or not the brand or the counterparty is allowed to use their content in perpetuity, or like if it's not in perpetuity, how long is that time frame? So I think the major points, besides general contract terms like termination or limiting indemnification, it's intellectual property and it's the payment terms. But when you approach these contracts, I encourage you to look at every provision with an eye for negotiating. That's what I did when I first started, and there's not a whole lot of consistency across the industry here, because it's so young, and so you can have a hand in creating and generating market terms for your own little client base, even if it's not quote unquote market or what other brand side attorneys are dealing with. I see some of these other questions. I'll just run through them, and feel free to drop them as I go through them.
Awesome.
Anonymous attendee. Well, there's a lot of anonymous attendee. Okay. Question is, what is the biggest or most common mistake you see content creators making while negotiating brand deals? It's handing away their name, image, and likeness. It's telling the brand, you have the perpetual right to use my name, image, and likeness forever without any further compensation. A lot of brands put that language in there because obviously it's great for them. And frankly, few brands have actually exercised this in a super egregious way, but that will absolutely change. And certainly with smaller creators, I have had some issues with brands abusing those provisions and just plastering the creator's name and face everywhere. So definitely the rights, to the creator's name, image, and likeness. Do state bars limit lawyers in this area? What about respect to contract governing law provisions? I think I'm not an expert in attorney ethics laws, but my read, and I did a fair amount of research into this, is if you're advising clients on general transactional contract law that does not relate or connect to a state specific jurisdictional, legal, whatever body of knowledge, then I don't think you have much to worry about. And that actually includes provisions that are choice of forum and governing state law provisions. Because even when you're negotiating those provisions, for example, in my practice, I usually negotiate and change those to California. Even if they were New York beforehand, suddenly they're California now. So even if there was an ethical concern that, oh, Julian's practicing New York law because this contract has a provision that says New York law governs, now it doesn't. Now California law governs because I negotiated that. So I think as long as you're not litigating in other states or, analyzing, I don't know, for example, like employment law related issues in the context of the brand deals, you should be okay. What measures should creators take to prevent unauthorized use or distribution of their content online? As soon as you see it, you need to go after whoever is infringing on your content. You cannot train people into thinking it's okay to use your intellectual property. And I would say 95% of the time, if you're aggressive about going after them, and that means emailing them, it means using their own social media platform to go and put them on blast, say, look, everybody, these people are taking my content and I've asked them to take it down and that's not right and they're infringing on my copyright. Most of the time, the folks that are using it will take it down. And if they don't, then you have a couple of other options. You can contact an attorney like me, or you can go through the small claims copyright court in Washington, D.C. and file a formal action there. But in short version, you got to go after them. How do I stay informed about legal issues related to emerging tech, such as virtual reality or AI in the content creation space? Really good question. I read several Substacks that cover the legal world. One of them is called Point Two. It's by Matt Margolis. Yeah, he's a fellow lawyer creator, and he does a lot of analysis of ongoing and very much what you said, emerging virtual tech related cases, and that helps me stay in the loop. But also, I think all of this is bleeding edge, and the attorneys out there like myself that are deciding to work in this area of law that, especially with AI, is not really fully built out. We need to just do a really thorough job researching, for example, how AI will impact copyright law, and understanding like the policies that these platforms like OpenAI are providing to creators regarding intellectual property. just staying on top of it as much as possible. And that includes reading the terms and conditions of these companies, and of course, keeping up to date with legal news, like I said, with newsletters on Substack, and also like, Law 360 and American Lawyer. There's a lot of good commentary out there. How do content creators navigate fair use issues without infringing on copyright laws? Better safe than sorry. Fair use is one of those things that it's not a reasonableness standard, but the key to think about is, does your content stand on its own without using the other media that you're showcasing that's somebody else's? If the primary value add or proposition in your piece of content is coming directly from that other piece of content that you're using, it's probably not going to fall under fair use. So in general, what I advise clients to do is either add their own commentary or change the content that they're sampling from so that it's not just directly replicating it, and that typically avoids fair use issues. I will say I will not speak specifically for music in this context, because music tends to be very, very protective, and it's very difficult to get away with sampling or using, for example, somebody else's music. Aside from if you're using it as background noise in the video or like, the soundtrack, that's different because you're typically crediting the musician in these platforms. How do you handle revenue sharing negotiations with platforms? I usually defer to my client on what they expect. Different clients have different expectations. Some are saying, with a client I recently had with Snapchat, they wanted 50% of all of the profits. And they're like, I won't take anything less than that. Otherwise, this isn't worth my time. And so I honor what they want and I negotiate accordingly. But there's typically, I haven't personally found there to be any sort of market standard on revenue sharing with partners or platforms. It's typically whatever the client thinks is worth their time. And then of course, my job is to advocate and get that done in the agreement. Do state bars limit? Oh yeah, I think we hit that one. Have any content creators gotten insurance coverage for the wretched indemnity provisions? No, but that's probably a good idea, because as we talked about, it's a big red flag in these contracts, and it has huge implications for the creators. But no, not yet. Mostly because these creators probably don't know what they're doing. What the indemnification clauses actually operate to do. And by the time they find out, it's typically with me. And then when I'm involved, I will usually, negotiate on their behalf to limit indemnification. How has the rise of platforms like Patreon and crowdfunding impacted the legal aspects of content creation, and what precautions should creators take in those spaces? I think it's enhanced it. I think the more platforms that people are creating out there and companies provide that help the creator connect with their audience, I think that's only beneficial for the creator economy, because not all creators are created equal. One is going to be really big on YouTube. One's going to only do short form on TikTok. Some are going to be more like me, that are like kind of omnipresent and then doing like written work. And some like to have, the more personal content behind paywalls so that they feel a deeper connection to their audience, like Patreon. So, I think the same issues that we've been talking about regarding protecting intellectual property, negotiating basic contract provisions in their favor, those apply equally, I think, irrespective of platform. With Patreon specifically, since you mentioned it, there's a concern there that since you're providing something that's behind a paywall, that somebody can reproduce it or post it elsewhere and then essentially violate the fact that it's supposed to be paid content. But in that case, we're back to the square one issue of what happens when someone is unauthorized. Someone who is not authorized takes your content, posts it elsewhere. What do you do in that scenario? And as we've discussed, you just got to go after them. So I think it's just a good thing, honestly. Just more platforms, more support for the creator community. It's only helpful, in my opinion. How do you counsel up and coming creators who want to sign multi-channel networks offering less favorable deals when they're laser focused on growing their audience or following? I give it to them straight, and as a creator, I get it. When you're trying to grow and just get in front of people, you don't care what you're giving away because you're not making any money. You don't know if this thing is going to end up anywhere. It's basically a one-man startup. And there's no profitability at the beginning, and you're busting your back, just to put out all the content. And so I tell them, look, if your goal is to grow and you don't mind giving away this, here are the risks, and it's up to you. And to your point, many creators who are hyper focused on growth They don't care. They tell me, I don't care what I'm giving away. I just need to get this deal because I need to keep the business going and I need to grow, and it's just not that important to me yet. One related point, and I think I touched on this in the webinar, but a lot of creators don't see the value in hiring or getting legal counsel. Part of what I've had to do as a lawyer for creators is also educate the creator community broadly that it's important that you have some legal person, be it an attorney or a friend or even a paralegal, even someone, in a management company that has some legal expertise. Somebody should be taking a look at these agreements because they can really, bite them in the butt in the long term. So, all right. I think that is all the questions we got. Thank you, guys. I appreciate it.
Thanks for joining us today, Julian, and thank you all for your questions. Since we're almost out of time for today, I'm going to go ahead and hand things back over to my colleague, Marina. But thank you again for joining us, Julian.
No problem. Thank you, everybody. Take care.
Thanks, Julian. Thanks, Nina. And thanks to all of you for being here today. As promised in the beginning, I am back to kind of go over some of those housekeeping things that you might have questions about. But the first thing I did want to point out to everybody is one of the things that this webinar today really drove home, I think, for a lot of us, is how digital our society is becoming. Lots of people are spending lots of time on the internet. And so for those of you who are looking to grow your practices and kind of get in front of people who are using this new technology that continues to grow, not that the internet is super new, but more and more people are using it every day, I encourage you to focus on your digital marketing solutions as part of your practice. And Justia can certainly help with that. One of the ways we do so is the Justia Lawyer Directory. Now, to be here today, that means you already have a claimed Justia Lawyer Directory profile. So check that out. Make sure it's up to date, got the most information about you for your potential clients, has a great photo, all of those things so your profile is more engaging. And of course, if you want to get that profile before even more clients on our platform, then I encourage you to explore the opportunities available with Justia Premium Placements. And you're welcome to give us a call or submit a contact form via our marketing website. Somebody would be happy to just go ahead and talk with you about what Justia Premium Placements can do for you. Now, have a great weekend and a great rest of your day.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.